This is another kind of a softball question, but I think it's a good one because it's one of those ones that maybe some people out there are thinking, and they might even say the question wrong, as this one is, and it's innocent, and it's important to kind of clear this up. Do I need a patent attorney to file a trademark? Okay, no laughing. This is good. They're asking questions. That's a wonderful start. The answer is no. The answer is no. You don't need one. We talked about a couple of things today. In that you could do it yourself, don't do it. Likely should, in best case scenario, work with a trademark attorney to file a trademark. All right. Hey, it's all right. And some people get confused. I mean, we've got both patents, but we offer a trademark. So is trademarks a kind of patent? Well, no, it's actually not. It's a separate area of law. And that's why we've got Matt and I on the show. I'm a patent attorney. That is the lane I am in. Matt is in trademarks. Separate lane, protects different rights. Patents protect inventions, protect the ability for you to be the only player for a limited time to make, use, and sell that exact invention. Whereas trademarks, Matt, go on forever, potentially.
Yep. As long as you continue to use them, keep them registered at the USPTO. And, another thing that I think is interesting too is that I think, the quality of services you're going to get from someone who is a patent attorney when it comes to filing patents is generally going to be higher than the quality of services you're going to get from an attorney who files trademarks, who's not necessarily focused on trademarks. So for those listening at home, to be a patent attorney, you have to sit for the patent bar. So it's a separate test. You have to have an engineering background, and then you have to sit for the patent bar, pass that bar in order to appear before the USPTO in patent matters. There is no such requirement on the trademark side. You don't need to be you need to be an attorney, obviously, but you don't need to be an engineer or have passed the trademark bar. That'd be cool if there was one, though. I'd love that.
It would be nice, I suppose. I think it's like a lot of different specializations, areas of law. Yes, it sounds like you can go to call it a generalist attorney, and they can say that they do trademarks, and that's legitimate. However, if they have not dedicated a lot of their career to it, they're probably going to miss a lot. And you're probably going to be underserved, in terms of what you're trying to do for your brand. And so someone like Matt who's dedicated his career to just doing trademarks, that is outstanding. That's going to be amazing service. You're going to get a whole lot more done in a short amount of time. And same on the patent side, although it's different. Not just any attorney can do it, can help and advise on the patent side. But quickly, one cool thing and one potentially cost-saving thing is you can hire a non-attorney, a patent agent, to help you as well on the patent side. Now, I'm not going to bash patent agents. They're just limited a bit. They cannot provide legal advice. They can't give you that, sort of lessons learned, what this is likely going to happen if this were litigated or if it goes to court. And so aside from that, they can still perform solid searches and do applications for you and walk along the side. So another option.